So the topic given to me today is the difference between new labor code and the existing one. This new labor code has been in discussion almost for the past 18 years. Finally, the beginning of in this year, 2022, the central government announced that the new labor codes will be implemented in this July 2022. Everyone was expecting it actually. Many employer federations, they welcomed this new labor code. Eventually, many labor federations, they opposed the implementation of this new labor code. Finally, the center decided to postpone the implementation of new labor code in India. The existing labor laws, almost 29 labor laws, including Industrial Disputes Act 1947, Factories Act 1948, Payment of Bonus Act 1936, Minimum Wages Act 1948, ESA Act 1948, PF Act 1952, Trade Unions Act 1926, Employees Compensation Act 1923, and so on. The new labor code has been categorized 4 areas. One is Code of Wages. Second, Industrial Relations Code. Third, Health, Safety, and Working Conditions Code. Then Social Security Code. These are all the 4 categorizations have been made with the new labor laws. Earlier, before this, we had 3 categories. That is labor laws relating to social securities, labor laws relating to working conditions, labor laws relating to service conditions. Service conditions includes Industrial Disputes Act, Standing Orders Act, etc. Working conditions includes Factories Act kind of acts. Social security condition includes Employees State Insurance Act, ESA Act, PF Act, Graduate Act, etc. Now they have made all these 29 acts into 4 categories. As I said, 1, Code of Wages, 2, Industrial Relations Code, 3rd, Social Security Code, 4th, Occupational Health, Safety and Working Conditions Code. Actually, they have not made any major changes in this new labor laws. They have made partial changes only in this new labor law. Very importantly, they have announced that industries which are employing more than 300 employees in their premises, they can close down the factory even without approval from the government. This made the employees federations, all India employees federations, trade unions to oppose the new labor code. Apart from this, new labor code also says that the employer can make agreement with the employees, that is trade union, and they can extend the working hours up to 12 hours a day, which means that weekly 4 days they can work and they can take rest for 3 days. Weekly 3 days will be holidays. Actually, in Factories Act, we had a provision called spread over, which means that any employer can extend their employees' working hours from 8 hours to 10.5 hours, even up to 12 hours, subject to the provision, subject to the approval from the Inspector of Factories. So this section, this spread over, has also been included in the Factories Act 1948 before itself. But now again they have made it as an option for the employees and the employers. They can have jointly an agreement that they can extend the working hours. The main objection of the labor federations on this labor code is closure of the factories. In Industrial Disputes Act 1947, we have already made so many provisions relating to strike, lockout, layoff, retrenchment, and closure. Earlier in Industrial Disputes Act 1947, we have said that the factories which are employing 100 employees, they can close down the factory without approval from the central government or state government, that is appropriate government. Now, the new labor code gives entry for the employers who are employing more than 300 employees. So they can also close down the factory without approval from the government. So this makes employer federations to oppose this new labor codes implementation. Apart from this, on ESA Act 1948, any employee or employer who are in hazardous process, they can take up ESI's registration. Previously, we had a provision in Factories Act and also under Industrial Disputes Act 1947 that the premises which are employing more than 10 employees, they can only get a registration of ESI and PF. Now this new labor code gives entry to the process like hazardous process. Even a small industry which is employing 2 or 3 employees, they can also take a ESI's code, ESI's registration. They can also get the ESI's. And this new labor code has not made any major change in ESI benefits. ESI, we have 6 benefits according to ESI Act 1947: sickness benefit, medical benefit, maternity benefit, disablement benefit, dependence benefit, and funeral benefit. And this new labor code has not made any changes in ID Act, Industrial Disputes Act. Industrial Disputes Act says that if an employee, if the employees union or federation, they want to go on strike, they will have to give notice to the employer before 14 days of start striking. The same has been again said in the new labor code also. Employees cannot go on strike without giving notice before 14 days. The same has been repeated in the new labor code. Only the closure part, they have made a difference. That is employees, more than 100 employees, the companies which are employing 100 employees, up to 100 employees, they can close down the factory without approval. Now it has been increased to 300 employees, which means that large scale, even large scale industries, they close down the factory when they face some issues in production, sales and marketing, or issues related to industrial relations, or issues related to unions. So employees are afraid that companies are free to close down the factory at any point of time when they have some dispute with their employees. So that is the fear of the employees and employees federation on implementation of new labor code. And very importantly, this new labor code says that the companies can employ FTE, which means that fixed term employees. They can employ any number of FTEs in their premises. They don't have to have regular permanent employees. So this is also an important point which makes the employees federation to hesitate to accept this new labor codes. Already today we are seeing most of the industries, they are running with the support of contract employees. We have an act called Contract Labor Act 1970, in which the employers are free to employ contract laborers. This has been in existence already, but still the contract labor clearly says one word that is called perennial nature, which means that casual nature, the process which is not connected with the business, that is perennial nature, casual nature. The casual natured works can be carried out with the support of contract laborers. That is what has been mentioned in the Contract Labor Act 1970, which means that companies, manufacturing industries or service industries or IT, whatever it is, they can employ any number of contract workers on their perennial natured jobs. That is casual natured job. That is housekeeping, security, canteen, gardening kind of the processes which are not at all connected with production or allied services. In those services, the contract laborers can be engaged by the contract labor by the employer. But now the new labor code says that contract laborers can be, that is FTE, fixed term employees, can be engaged in any process. It may be in production, quality, maintenance, security, housekeeping, canteen, whatever it is. They can employ, employers can employ any number of FTEs in their manufacturing facility. So this also makes the employees to be in fear to accept the new labor. So this gives entry to the employers to employ more number of contract employees, that is FTEs, fixed term employees, which doesn't give confirmation or regularization of employees. So this new labor code has made a change in the Contract Labor Act 1970. Even today, we are able to see that every manufacturing industry, almost 100% of the manufacturing industries, they are employing contract laborers only in all their departments: production, maintenance, quality, production planning, kind of all departments, they are employing contract employees. So now this new labor code confirms that employers can continue employing contract laborers in their manufacturing premises. So this is a small contradiction in the existing Contract Labor Act 1970, and the employers don't have to give confirmation or permanent status to the worker. We already have an act in the existing act, permanent status to permanent status to confirmed employees. That is an act. So every employee who has been employed in the company for 480 days, previously it was 240 days, every employee who is in the confirmation stage. So previously we had all the employers can employ the contract laborers in the manufacturing process. For them, they don't have to give confirmation at all. But previously, it is told in the confirmation status to Permanent Employees Act. For example, an employee is working more than 480 days, continuous service. Continuous service means he should be employed on a regular basis. He can have weekly off and earned leave or casual leave he can avail. Apart from that, there should not be any breakage in this 480 days. When an employee continues service for 480 days in the 2 years, this employee has to be confirmed by the, so that is what has been mentioned in the confirmation status to Permanent Employment Act. So contradiction to this act, this existing act, new labor code says that companies can employ n number of FTEs, fixed term employees. He may be an engineer, he may be an HR executive, he may be even worker, fitter, whatever it is, companies can employ a number of FTEs. So this is also an important objection by the Employees Federation. In a Trade Union Act 1926, there is no much change in this according to new labor code, because according to Trade Unions Act 1926, the companies which are having more than 100 employees, from there even 7 employees can join together and start union. If the company has less than 100 employees, at least minimum number of employees to form a union should be at least 10. That is what has been mentioned in the trade union. That is not been made any change here. And in Factories Act, Factories Act says that in Factories Act we are using a word worker. In ID Act we are using word workman. But this new labor code says worker. So all workmen are worker. Both are same only. So both can be in the same terminology. So worker also is. So worker is equal to workman. So that is what it has been said in the new labor code. So this definition of worker will be based on the basis of wages, the fixed based on wages. But as far as Factories Act or industrial disputes are concerned, when you say worker or workman, any employee who is employed in a factory directly or indirectly through any agency or directly with the principal employer, with or without wages, they are also called as worker, they say. But as far as the new labor code is concerned, the definition of worker has been slightly changed. So the employee's salary, the employees getting salary up to 18,000 rupees will be falling under this worker category. That is what the new labor code says. The employees can raise industrial dispute with the employer within the time limit of 2 years. Now, according to new labor code, it was previously 3 years. When an employee, for example, an employee has been dismissed from service by the employer, he can file a case in labor code even before, even up to 3 years before. So now, according to new labor code, it has been reduced. The time of case, it has been reduced to 2 years. Within 2 years, he has to file a case. If it is beyond 2 years, 5 years or 6 years, he cannot file the case. And also there is one definition according to section 2M in Factories Act. There is a provision called occupier. Occupier means that the person who has ultimate control over the affairs of the factory. That is called occupier. Now we call occupier as a plant head, and the person who is heading the plant, the person who is heading the premises, he has been called as occupier. Now, according to new labor code, they are giving little more other definitions for this employer, for this occupier or employer definition. The employer means head of the department, occupier of the factory, manager of the factory, contractor, and legal representative of the deceased employer. So they have mentioned like this in the new labor code. And also there is one industry definition has been pending under Industrial Disputes Act 1947. So in the current industry definition in the Industrial Disputes Act, it's different. Now they are making it slightly different. That is any systematic activity carried on by cooperation between the employer and his workers, whether such workers are employed by such employer directly or through any agency, including a contractor. The definition has specifically excluded institutions owned or managed by organizations wholly or substantially engaged in any charitable, social, or philanthropic services, sovereign functions, domestic services, etc. So previously we call industry any premises which are having a 10 or more people with the aid of power, or 20 or more people without the aid of power. That is called as industry previously. Now they are making it a small change in this new labor code. Any systematic activity carried on by cooperation between employer and employee. So they have made a change like this. When you implement this definition of industry according to Industrial Disputes Act 1947 on the new labor code, when you implement this, all educational institutions like schools, colleges, everything will be coming under industry definition. So they also should be the teachers or non-teaching staff working in all educational institutions, schools or colleges, whatever it is. They are also to be provided salary on the particular day. They are also covered under ESPF Act. They are also covered under Gratuity Act 1972. All that. But as of now, they are all not covered actually. As of today, according to Industrial Disputes Act, the teachers and the people working in schools and colleges, they are not covered under Industrial Disputes Act. But the new labor code covers all this because the definition changes like any systematic activity carried on by cooperation between employer and its workers. And they're also making some small changes on the definition of wages. I'll just read out. Definition of wages has been revised. The first part includes all salary components expressed in terms of money or capable of being so expressed, like basic salary, all reimbursements, all allowances, and all benefits. Second part of definition provide specific exclusion like bonus payable under any law, conveyance allowance, house rent allowance, overtime allowance, house accommodation, supply of light, water, medical attendance, other amenities, service excluded by a general or special order by appropriate government, commission, contribution to provident fund, pension, all these have been excluded from the definition wages. But previously, when you say wages, even all these components, even the cost of food grains supplied at the subsidized rate, that is also has been included in the definition of wages previously. Now it has been excluded. Then third part of definition of wages provides that total excluded components should not exceed 50% of the total remuneration. Every employee has to get 50% of his wages monthly on his hand as a take-home salary. There should not be any deductions beyond 50%. He has to take at least 50% salary to his. So that is what it is also mentioned in the payment of wages. That's no difference here. Actually, in the Industrial Disputes Act 1947, the strikes and lockout, layoff, retrenchment, closure, all these have been mentioned as industrial disputes in Industrial Disputes Act 1947. When the employees go on strike, they cannot do the strike immediately. They have to give notice, 6 weeks notice to the management. Before they start striking out, they have to give 6 weeks before notice to the management that they are going to. But after serving the notice, after 14 days, of serving the notice, the employees can start striking. That is what has been mentioned in the Industrial Disputes Act 1947. But that has been made, slightly changed in this new labor code. And now they have removed that 6 weeks notice. They have clearly mentioned that only 14 days notice is necessary. 14 days notice is enough, necessary, that is mandatory. Without giving such notice, they cannot go on strike. Earlier also, they cannot go on strike without giving any notice. But the notice time was 6 weeks. Now it has been reduced to only 14 days. And the worker may approach the industrial tribunal for adjudication for the dispute-related dismissal, retrenchment, or termination within 45 days after the application for the conciliation of the dispute was made. Now the term has been fixed. They should approach industrial tribunal or national tribunal for any dispute, dismissal, or retrenchment, or any dispute. They have to approach the adjudication authority within 45 days. If any employer who is employing more than 300 employees in their premises, if they close down the factory without any approval from the appropriate government, which means a central or state government, if they close down the factory, they will be penalized minimum 1 lakh or up to 10 lakhs. Previously, the fine was less. Now the fine has been increased for the employers who are closing down the factory without getting any approval from the inspector of factories, that is government. If it is less than 300 employees, naturally, as I said earlier, so they can close down the factory even without any approval from the government. And also there is one act called Payment of Subsistence Allowance Act, under which if an employer suspends any employee, so the employer has to give at least 50% of his wages on the employee's suspension for first 90 days of suspension, and 91 to 180 days, the suspension, the subsistence allowance is being increased to 50% to 75%. If the employer suspends the employee more than 180 days, he has to give him 100% of his wages. That is what has been told in the Payment of Subsistence Allowance Act. Now, this new labor code says that maximum is 70% only, 75% up to only 90 days. If the employee gets suspended more than 90 days, only 75%. This new labor code doesn't allow the employer to pay 100%, even if the suspension continues after 180 days. So in PF Act, any employees, any employer who is employing more than 20 employees, they have to be registered under PF. They have to get employer code, and they have to deduct PF contribution from the employee, and the employer also has to pay 12% on employee's PF account. So that has been maintained. The new labor code, there is no change in that. If an employer if an employer deducted the PF contribution of employee, but he has not paid it to the PF account, then he will be penalized. The penalty amount has been increased to from 10,000 to 1 lakh, and the imprisonment is also possible under the act. Previously, according to Gratuity Act 1972, every employees, there is a definition, there is a beautiful definition for gratuity under the Gratuity Act 1972. Gratuity is a free gift given by the employer to the employees who have given their loyal service to the company for at least 5 years. That is what the definition of the gratuity. There is a formula also, like basic into number of years of service into 15 divided by 26. There is a formula for gratuity. So accordingly, the employer has to give gratuity to the employees who have served at least for 5 years in that company. So previously, the gratuity eligibility for gratuity is 5 years. If the employee has worked for more than 5 years in the company, the employee has to give gratuity. Now in the new labor code, it has been changed that 1 year. The minimum eligibility to claim gratuity for an employee is 1 year. If the employee has worked for more than 1 year, the employer has to give gratuity to the employee. And also the Gratuity Act 1972, it has been amended, I think in section 9(2). So they have said that the compulsory insurance, every employer, because there are a lot more employees are not getting response from the employer when they are applying for claiming their gratuity. So the existing Gratuity Act has already been amended by the central government, that every employer has to do a compulsory insurance, because the employer doesn't have to pay to the employee, because if the employer has to pay, he is not paying. In many cases, he is not paying. He is postponing the payment. Finally, it becomes a dispute. The employee goes to court. So a lot of legal issues are happening. To stop that, in Gratuity Act, already we have made an amendment that every employer has to have gratuity insurance, compulsory insurance. If an employee joins today, if an employer executive, whoever it is, he joins today, from next month, the employer has to pay gratuity insurance to the insurance company. If the employee leaves service after completion of 5 years, the insurance company will pay the gratuity to the employee, not the employer, because he has paid for the insurance. Now the gratuity eligibility has been reduced from 5 years to 1 year. The employees who have worked for more than 1 year, they have to be paid gratuity. That is also going to be paid by the insurance company, not by the employer. So the employer doesn't have any head on this Gratuity Act amendment or even new labor code. So this new labor code talks about Employees Compensation Act 1923 and also the building and other construction workers, that is unorganized workers. There is an act called the Unorganized Workers Social Security Act 2008. So this new labor code has made change in that also. Creation of social security boards for unorganized workers, coverage of platform workers and unorganized workers under the ambit of social security scheme, code to expand the sources of the fund for schemes to include funds from corporate social responsibility or any other source may be specified in the scheme, and also contains enabling provisions for constituting the special purpose vehicle for the purpose of implementation of schemes for unorganized workers. Contribution from an aggregator will be at rate notified by the government, which can fall between 1 to 2% of the annual turnover of the aggregators. However, the maximum limit such contribution fixed at the rate of 5% of the amount paid or payable by an aggregator to gig workers and platform workers. Remaining the designation of inspector as inspector cum facilitator who is expected to supply information and give advice to employers and workers concerning the most effective means of complying with the provisions of the proposed code. Then there is a code called, there are 4 codes I mentioned, the Occupational Safety, Health and Working Conditions Code 2020. According to this code, the employee appointment letter has been made statutory. Previously, no act talks about the appointment letter. If an executive is being removed from service, if an executive gets dismissed by the employer, mostly the executives will not go to court. Only the employees, when they get dismissed or when they get suspended, they go to court. Executives don't go to court because most of the labor laws don't support executives removal or dismissal. But there is one act called Indian Contract Act 1872, under which any 2 parties or 1 party and 1 organization or any 2 organizations, when they make an agreement, they both have to follow what they have mentioned in the agreement. So according to that act, if an executive gets dismissed from service, this executive can file a case under the Indian Contract Act 1872, stating that whatever has been mentioned in the appointment order, for example, every company will give at least 1 month or 2 months or 3 months notice when an executive wants to resign, or when an organization wants to send an executive out. So there should be at least 1 month or 2 months or 3 months notice. That is in practice. If the company sends an executive out immediately without giving any notice period time, so the executive can file case according to Indian Contract Act 1872. So now the appointment letter has been made statutory. All employees or executives have to be given appointment letter under this act. Previously, it was not at all mentioned in any of the acts that every employee has to be served appointment letter or something like that. Now the new labor code ensures it says that appointment letter is mandatory. And also this new labor code allows women to work in night shifts also. Previously in Factories Act, evening 7 p.m. to morning 6 p.m. no women shall be working in any industry or any factory. But now for the past almost 5-6 years, the local factories will get factories are getting the HR heads. They get approval from the local inspector of factories or local labor commissioner or whoever the authorities. They get local permission from the local government department that they are employing the women. So most of the places it has been happening, but it has not been mentioned in the act. So now the new labor code gives space to women. They can also work in night shift with their consent. But the thing is, they will have to be given proper transport and safety, proper transport facilities, as well as the employer should ensure their safety. That has been mentioned in the new labor code. Even the time restricted under Factories Act 7 p.m. to 6 a.m. no women shall work. But the new labor code says that even from 7 p.m. to 6 a.m. the women workers or executives, they can be employed in any premises provided with their consent. And also rights and duties of employees and employers. Rights and duties laid down in the new code for employees too. Employees shall take care of their own health, shall comply with the specified safety and health measures, shall report to unsafe situations to the inspector, labor inspector or factory inspector. This new labor code has been having some modified and modified provisions and interstate migrant worker, but excludes part-time employee regularly employed in mutually accepted standards of conditions of employment and entitled to social security benefits. The new definition of core activity provides that activity for which establishment is set up, which means that production is the main function of a factory, and other activity like housekeeping, security, canteen, etc., not to be treated as core activity. So these housekeeping, security, and canteen, these are all the places which are not treated to be a core activity. So that has been mentioned in the new labor code. Principal employer to provide welfare facilities where a contract labor is deployed. That has been mentioned in the Contract Labor Act 1970 also. Principal employer shall be liable to make payment of wages to the contract labor deployed by him. That is also has been mentioned in the Contract Labor Act 1970. Then about overtime, when an employee does overtime more than 8 hours a day, correct fact is that an employee can work up to 9 hours a day, weekly 48 hours a day. If more than 9 hours or more than 48 hours in any week an employee works, he has to be paid double wages, which means that twice the rate of ordinary rate of wages. So that has been, again mentioned in the new labor code. There's no change in that. So this, as I told you previously, the employee definition, worker definition has been changed. Whoever gets less than 18,000, they are all called as worker. Under the, so this has been, we have an act called Interstate Migrant Workmen Act. Even in that, they have, that has been again included in the new labor code. Here also, the worker ceiling is 18,000 rupees. Interstate Migrant Workmen Act. So when they are getting, less than 18,000, they are also called as. The new labor code, actually it is order of the day, but some positions from different states and different labor federations. Initially, when it was introduced, the people who came to know that we get a weekly off for 3 days. Weekly 4 days only we are going to work. So rest 3 days will be weekly off. When the employees came to know this, they appreciated, they welcomed this act. Once they started realizing there are some points which may affect their livelihood, so the employees started opposing. So the first point is the employees, as I told you, the employer can close down the factory if they have less than 300 employees without any approval from the government. Second is the FTE, fixed term employment. These two major points for which employees federations are opposing this. But most of the other areas of this new labor code are really appreciable. Most of the countries, most of the states have started discussion on this among the states. They have also made rules, because the rules are made in the assembly, how the act is going to be implemented in this particular state. That is a rule. So rules have been made by the local assembly, state assemblies. Act is enacted in the parliament. Once the new labor code has been enacted in the parliament, it has been sent to all the state governments. Some of the states, they are very fast in understanding this labor code. They also appreciated this labor code, and they have found, they have created a new labor code rules in their assembly, and they have sent it to the central government. So they're waiting for the central government's approval. Once the central government approved it, those states who have already made the rules and they have sent it to government, so those states will be implementing this new labor codes in their states. But other states, they have not started the discussion. They have not made rules, and they are still opposing it. They are asking the central government to make some changes in the new labor code. So actually, this new labor code, it is not implemented suddenly. So it has been in discussion from the last government itself. Almost for the past 18 years, it has been in discussion. So now they have finalized the draft, and they have they wanted to implement this, but some oppositions are coming. So the government has to discuss with other federations and other states, and then they have to take steps on this and how to go with it, how to what are the changes they require. So that has to be. So this labor laws, we are not having the labor laws whatever have been made by the British or later on post independence. Every year we have been making a lot of changes in all the labor legislation. Whatever act you take, right from Factories Act to any act. So whatever act you name, so those acts have already been made a lot of amendments in those acts. Previously, we had only 10 lakhs gratuity ceiling. Even if the general manager or vice president working in a private company, he gets retired after his 58 years or 60 years. If they, according to the gratuity calculation, comes around 15 lakhs, he will be paid only 10 lakhs according to gratuity at 1972 previously. That has been named, that has been now removed. The ceiling has been removed now. So now the gratuity, whatever it comes, it has to be paid to the employees. Like that, so many changes and so many amendments have been made in the all labor legislatures. Now, since we have 29 acts, the center thinks that there should not be any overlapping. For example, wherever the ESA Act applies, there the Maternity Benefit Act and Workmen Compensation Act will not apply, because whatever the provisions have been given in Maternity Benefit Act and Workmen Compensation Act, all those provisions have been already made in the ESA Act. So like that, there are some overlaps in the among the labor laws, around 29 acts we have. So the government wants to connect all the laws instead of having too much of acts. So they want to reduce into different codes. That's why they are removing all the laws and they are making into 4 codes, as I said: Code of Wages, IR Code, Industrial Relations Code, Social Security Code, Occupational Health, Safety and Working Conditions Code. They are classifying all the 29 acts into these 4 codes. So they want to simplify the acts. So the change is, there is a saying called the change is constant. So we have to be ready enough to face the changes, otherwise we'll be obsolete. So the country has to be ready to face the change. So that is what, even for example, as I told you before, women are not allowed to work in night shifts in Factories Act 1948. So now the labor code allows women to work in night shifts. Contract laborers are engaged are not allowed to work in production according to Contract Labor Act 1970. But now the new labor code allows all the employees to work in any department. Even FTEs also, the companies can employ any number of FTEs. That's what has been told by the new labor code. So according to the situations and circumstances, all the acts and laws have to be amended or updated, because people mindset are changing, lifestyle is changing. So suitable to that, the center or state has to adopt the changes in the labor laws. So that is what a brief about the new labor code. So I have not gone act by act or section by section. I just within this stipulated time, I just have given a brief about the difference between the existing labor code and the new labor code.
Son, one participant is asking, can you guide regarding shop and establishments and ESIC for NGOs?
No, shops and establishment, this act applies to shops and other offices. I'm not seeing any change in the shops and establishment definition, but the ESA attracts shops and establishment. Even the people working in the shops, they are also to be covered under ESA. They also have to be given the ESA facility according to ESA Act 1947. Wherever any premises wherein 10 or more people are working, they have to be covered by ESA Act and PF Act. Now, according to new labor code, that has been increased to 20. Any premises wherein 20 or more people are working, they have to be covered by ESA and PF Act. So shops also are having the ESA facility.
Is PF applicable if less than 20 employees? PF applicability.
No, yeah, you're talking about PF applicability. According to PF Act, any premises wherein 10 or more people are working, the PF is applied. But the new labor code allows 20 or more people if you're working, so that the PF has to be applied. As of now, if you have only 10 employees, you don't have to get a PF code.
If salary is paid to shareholders or director, then PF is applicable.
No, PF, they have a ceiling up to 20. It was previously 15,000 rupees. Now, according to PF Act 1952, it has been increased to 21,000. The employees, those who are getting up to 21,000, they are only is eligible to get PF. So directors and shareholders, if they are getting, no, shareholders, it is share, it is not salary. There is as I discussed in this comparison, there is a definition for wage and salary. Okay, the share is not a wage. Share is not coming under the wage definition. So shareholders will not be deducted PF, but the director, if he is a paid director, if he gets a salary on monthly salary, he can be allowed on PF. That too, his salary should be less than 21,000. Then only will be covered. If the employee has more than 21,000, he has an option. He cannot dictate the employer to deduct PF from his account, but the employee can himself contribute to PF according to his own wish, but he cannot compel the employer to pay PF. That is the employer's contribution. He cannot come. So only the employees are getting 21,000 up to 21,000. They are only are covered under ESF, PF Act, PF, ESF, both same ceiling 21,000.
Shed some light on the leaves and holidays as per the new act, new code.
Leave and holidays. Huh?
Yes, yes.
So we have a provision in Factories Act that for example, an employee has worked 300 days in the last year. So this employee has to be given at least 1 day leave for every 20 days leave. So for 300 days, you'll be given 300 divided by 20, you will be given 15 days leave. So that is a PL. So CL means that is a paid leave. CL means casual leave. Casual means every employee has to get at least 1 month, one day leave for every month. So for 12 months, if he has worked, he will get 20 days. So even for the leave, it is to be paid by the employer.
Okay, sir. So the next query is, what are the rules regarding overtime and its applicability?
No, overtime, as I told you, in Factories Act, they have clearly mentioned once an employee has worked more than 9 hours, he has to be given overtime. Overtime means double wage on his total wages. Many companies I am seeing, they are giving double on their basic salary. Basic will be 30% or 40% or maximum 50% of his wages will be calculated as basic. In that, companies are giving double wage. It is not so. Payment of Wages Act and also Factories Act says that the salary should be calculated per day. How much he gets it on total gross wages divided by 30 or 30 number of days in the month. So that should be calculated on overall wages, double on the overall wages. There is a word twice the ordinary rate of wages. Ordinary rate of wages means the full salary. Whatever he gets per month divided by number of days in the month. So that comes 1 day salary into 2. So that is double wage or the overtime. So every employee who is working overtime more than 9 hours a day or weekly more than 40 hours, he has to be paid double wages on his total wages.
Will these codes be more beneficial for employees or an organization or a company?
Yeah, that is what. So any decision made by the central government or private, whatever it is, any decision made. So that will be having two connotations covering both the parties. So there are two parties here. One is employer, another one is employees. Okay, so the center or state, they make law suitable to current trend. So then they make provisions suitable to those. Once we make some provisions favorable to employer, employees federation will spontaneously oppose. Once we make some rules for employees, employer federation will spontaneously. This is a very normal, natural phenomenon. The same way, here also we have a lot of benefits for the employees and also employer. But as far as I have seen this new labor code, this code is very much beneficial to the employees than the employer.
What are the major challenges for the implementation of these labor codes? Challenges.
The challenges are two. There are some political challenges, as we all know. Apart from that, this new labor code talks about closure of factories. Any employer can close down the factory if they have less than 300 employees. They can close down the factory without approval from the government. That is a main point which is opposed by many of the trade unions in India. And also the second point is FTE, fixed term employment. So already today, most of the manufacturing industries, they are employing contract laborers in India. But now after this new code implementation, employers will not allow regular employees. They will sack, they will almost, create, they will almost try to send all the employees out. I mean, permanent employees, they will try to engage more FTEs, which means contract employees. Once they engage more contract employees, the employer's labor cost will be comparatively come down because they don't have to give uniform to the employees. They don't have to give other benefits like transport, all that they don't have to give to the employees. But the new labor code says that whatever the regular employees are getting, the FTEs, fixed term employees, should also they should get all the benefits given to the new employees, like gratuity, statutory PF, ESA, all that. But as far as uniform kind of small things employer don't have to give. For that is also a cost reduction factor for the employers. So employers will definitely engage more fixed term employments instead of having more regular employees. Regular employees means it's a too much of headache to the employer in terms of cost as well as providing them safety and so many, they should give a transport, housing, business benefit, a lot of things they have to give. For FTs, they don't have to give all this. So they will definitely prefer FTs. That is a fear of employer federation today. So these two things have been a big obstacle for center to implement this thing, this act in India. So they will have to regularly talk to the all labor federations across India, and they should create some concerns. They should create a platform through which they can implement this new labor code. Yeah, thank you so much. Thank you.